Congressman Jamie Raskin has dropped a bombshell accusation against Trump's DOJ. Raskin says that as recently as earlier this year, in January 2025, Epstein prosecutors had an active and ongoing investigation into Epstein's sex trafficking operation. He says that Trump's DOJ killed that investigation, being run by my old office, the Southern District of New York. According to Raskin, nearly 50 Epstein survivors came forward to share their stories. Survivors identified at least 20 men they were trafficked to. Survivors laid out how Epstein's sex trafficking operation worked, who financed it, who enabled it, and they named names. Raskin got this explosive information from a credible source, attorneys for the Epstein survivors. Now Raskin is demanding answers. He sent a letter to Attorney General Pam Bondi asking why Trump's DOJ killed the SDNY's investigation. And that's where the plot thickens, because now Trump hasn't brought this investigation back from the dead. Instead, he ordered a new investigation to target Democrats for revenge, to distract from his own ties to Epstein, to give DOJ a reason to block the release of the Epstein files. So, where is AG Bondi sending this new Epstein investigation? To the SDNY. As a former deputy chief of SDNY's criminal division, here's my unsolicited advice to my former colleagues. Don't touch this. You know exactly what this is, a political hit job disguised as an investigation. You know that abusing prosecutorial power for political gain is wrong. You know the job is to follow the facts and the law without fear or favor. You know SDNY earned its reputation as the sovereign district for not bending the knee. Don't sacrifice your ethics, your integrity, or your reputation for this circus. They may appeal to your ambition. Do the dirty work and set yourself up for a front-page headline and a fast track to a job with a fancy title. Don't fall for it. It's a trap. The second things go wrong, and they will throw you under the bus. I know it's not easy to refuse an assignment, especially when doing so will cost you your dream job. But being a minion who does Donald Trump's bidding, that isn't the job you signed up for. Your U.S. Attorney Jay Clayton is a political appointee of Donald Trump, and he knows the fastest way to lose his job is to say no to the boss. And let's be real, Clayton was never an AUSA. He doesn't know how to do this job, but you do. Trust your gut, follow your principles, honor your oath. Don't become the next black sheep to disgrace the SDNY. In a world of Todd Blanches and Emil Bobies, be a Danielle Sassoon. Now let's talk about Raskin's accusations, because if they're true, this is an outrage. I've prosecuted many significant sex trafficking cases. What Raskin describes is massive. Nearly 50 victims, more than 20 men who sexually abused girls and young women, a network of enablers, and $1.5 billion in suspicious transactions? Bondi needs to respond. Is Raskin's accusation true? And if it is, she needs to explain why her DOJ shut down SDNY's investigation. It makes no sense to say that victims weren't credible. In my experience, a years-long open and active sex trafficking investigation means that prosecutors found credible victims. Otherwise, the investigation would have been closed a long time ago. And SDNY put several victims on the stand at the Maxwell trial. That doesn't happen if they're not credible. And if SDNY had an open and active investigation into Epstein's co-conspirators, then DOJ leaders also need to explain why they misled the public. Their July 2025 memo claims that DOJ didn't uncover evidence that could predicate an investigation against uncharged third parties. That implies there wasn't an investigation. If DOJ headquarters shut down SDNY's probe, that should have been in the memo, with an explanation for why. To be clear, it is unheard of for DOJ to rip away an investigation from the SDNY, much less to do that after several years, 2 indictments, and a conviction by a trial jury. If DOJ's goal was to hold Epstein's co-conspirators accountable, the SDNY prosecutors with institutional knowledge were best positioned to get the results. But that wasn't DOJ's goal. DOJ's goal was to protect Donald Trump at all costs. Why else would DOJ comb through the Epstein files for any mentions of Trump, brief Trump personally on their findings, and reverse course and hide the Epstein files after promising to release them? So what can Congress actually do? Yes, Congress can vote to release the Epstein files, but now the DOJ can refuse to release most of those files. Why? They can argue that releasing the files would jeopardize SDNY's new investigation. You know, the one Trump ordered into Democrats? How convenient for him. But all isn't lost. Here are 5 steps that any member of Congress, even Democrats in the minority, can take to force transparency and accountability. Step 1. Request the notes that were taken by the victims' lawyers from FBI's interviews with the victims. The notes taken by the victims' lawyers should be a good substitute for the notes taken by FBI agents that you would expect to see in the Epstein files. This gets Congress what is arguably the most important evidence in the Epstein files, the victims' accounts of criminal conduct and who they say is responsible. This approach also has a real advantage. It gives the victims' lawyers an opportunity to redact their notes to protect victims' identities before sharing them with Congress. Step 2. Review the materials to determine if criminal referrals are appropriate. If the victims describe criminal conduct by sex traffickers and other Epstein enablers, and the victims' claims aren't obviously false or biased, then members of Congress should make criminal referrals of the perpetrators to federal and state prosecutors. The referrals should include the notes from the victim interviews and supporting evidence. Step 3. With the victim's permission, make any criminal referrals public, along with the interview notes and supporting documents. Why? Transparency into the victims' accounts is the best way to build public and congressional pressure for prosecutors to act. And thanks to the speech and debate clause, members of Congress are immune from civil liability for releasing this information. Step 4. Interview former SDNY and Southern District of Florida prosecutors and FBI agents who worked on the Epstein and Maxwell cases. They can provide a roadmap for any congressional investigation. They can provide insight into criminal referrals. They can reveal Maxwell's lies. They can expose any DOJ corruption and cover-up. Step 5. Keep Maxwell front and center. She was convicted of sexually abusing young girls herself and helping Epstein abuse them, and she continues to lie about it. Biden's DOJ is responsible for convicting her and having her be sentenced to 20 years in prison. Trump's DOJ is responsible for her country club prison stay. That is a persuasive message, and maybe it makes Trump think twice about freeing her if public opinion strongly opposes it. Bottom line, if it's true that Trump's DOJ killed an open and active investigation into Epstein's co-conspirators, that is a devastating betrayal of the survivors. And now, to make matters worse, Trump has resurrected an investigation not for survivors, but to target his enemies and protect himself from releasing the Epstein files. The truth must be revealed. Epstein's co-conspirators must be held accountable, and Congress needs to fight for justice for the survivors who have been ignored, doubted, and silenced for far too long. Thanks for watching Courtside with Kristy Greenberg. If you enjoyed this video, please like it, share it, comment, and subscribe to my channel. I look forward to seeing you next time courtside.